The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please announce the case for the day.
Good morning. Situation in the Republic of Kenya. In the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang, case reference ICC 0109-0111, and for the record, we are in open session.
Thank you very much. Appearances remain the same.
Mr. President, just a minor change in the prosecution team. Mr. Lucio Garcia is no longer part of the prosecution team today, and Ms. Grace Go has replaced Ms. Suljanovic as the case manager.
Thank you very much. Defense?
Mr. Sang's team remains the same, but with your permission, Mr. President, our legal assistant will step out briefly and come back. Thank you, Mr. President.
No change, yes, Mr. President, and good morning.
Thank you.
The same, Your Honor.
Thank you very much. We're starting briefly in open session to take up a matter that has been brought to our attention by the VWU. It's been brought to our attention that the witness currently understand efforts are also being made by some people to reveal the identity of the witness, understand. And this is something the chamber thinks should be brought to the attention of the parties on both sides for a brief submissions, brainstorming, if you like, on this matter. The question specifically becomes this: if this continues, this effort at threatening and masking identity of witnesses, can we, in good faith, continue to hear the evidence of protected witnesses in public sessions? That's one matter I'd like us to discuss, just for 10 minutes. Prosecution.
Thank you, Your Honours. If I may address on this issue, it is obviously, it is a matter which has come to our attention as well, and it is obviously a matter of grave concern. For the moment, my submission is that we can continue to deal with it as we have been doing, but what we will request is that the Chamber grant us, the prosecution, a little bit more latitude in deciding what can be dealt with in private session versus public session. We understand the importance of the publicity of these trials, and this is important to the prosecution as well, not only to the defense. But when we are forced to go in and out of public sessions repeatedly, the potential for errors and slip-ups greatly increases, which, with the best of will, we can try to minimize, but being humans, the witness being human, the court staff being human, we expect that somewhere along the line mistakes will be made. So our request is that a little bit more latitude be given so that if certain questions might be put in public session but are a part of a lead-up to a matter which requires privacy, then we should avoid, if possible, having to go in and out of private session for individual questions. And that the solution would be to allow private session to be held in chunks, as it were, to deal with aspects of evidence to be ameliorated by the subsequent publication of public redacted transcripts. Our submission is that that would strike the necessary balance between the need for publicity and the imperative to protect witnesses, particularly in the light of what would appear to be concerted efforts to unmask witnesses, which in the prosecution view is a thinly veiled attempt at intimidation, which the Chamber, in our respectful submissions, needs to guard against. Thank you, Your Honours.
Mr. Keegan-Katwa.
Mr. President, on our part, the first thing that we wish to say is that my client, Mr. Sang, and my team has done everything possible to make sure that there is compliance with all the prescriptions and requirements of the court to protect the witness and the family members. My client would be extremely aggrieved if he were to be prejudiced as to his right to public hearing on account of issues relating to third parties which have nothing to do with him. Secondly, Mr. President and Your Honours, we pray that in considering this issue, the court bears in mind that the circumstances relating to the likelihood of the prejudice to the witness and their families could also be on account of the prosecution's handling of the investigations and the witness. And the defense should not be placed in a situation where they are prejudiced when it has not been determined who is to blame, and when that blame could quite easily be in the hands of the prosecution. For those reasons, Mr. President, we strongly urge that these proceedings be conducted in the open so that Mr. Sang's right to be heard, to have his case understood by the public, and his right to be able to investigate and to get witnesses is not prejudiced. Thank you, Mr. President and Your Honours.
Would your submission then be that it does not matter that there may be, as you put it, third parties and who might be trying to unmask the identity of protected witnesses, who might be threatening protected witnesses? It does not matter that those would be third parties doing this. Regardless, the proceedings must still be held in public. Is that your submission?
Mr. President, may I qualify then my submissions to this effect? First of all, to be fair, I could understand if there are concerns in respect to the witness and their families. And my submissions would be that the court do please balance the rights of my client and what the prosecution are seeking to obtain being closed sessions, and the interest of the witness and the family. And Mr. President, we would pray that that be on case-to-case basis. It should not be just an open-ended check, that the prosecution are entitled to conduct this, to have these proceedings conducted in closed session, or by way of multiple ex parte processes to our exclusion. Mr. President, may I also say that my client's position is that the publicity of redacted transcript is not a cure to his right to public hearings. He does not accept that merely because a transcript will be made public, it's good enough for him to forfeit his right to public hearing. He would still insist on public hearing, Mr. President and Your Honours.
The balance you speak of, has that not been struck if the intention of the court, and of course the prosecution, Mr. Steinberg himself, has said, as far as is concerned, efforts must be continued to be made to hold as much of the proceedings in public as possible, subject to the need for greater latitude for them to go into private sessions to discuss certain of the evidence. And if the court has been minded to do that, hold as much of the public of the testimony in public session, yet efforts are being made by some people to figure out the identity of the witnesses and publish the identity. Are you saying that a balance would not have been struck if the court has now to increase measures to protect witnesses?
Mr. President, my position is that the greater latitude that the prosecution is asking for is something that we are opposed to. It is our position that in every instance they need to come before you and make the request and justify the reason why they should be allowed to go into private session, as opposed to an open-ended permission that they have been given latitude so they can invoke it from time to time. We would pray that at every instance they justify and ensure that they have grounds to deserve that accommodation from you.
Or are the efforts to unmask identity of protected witnesses, is that not enough justification to go into a heightened measure of protection for protected witnesses while they're testifying in the courtroom? Is that not enough justification in the circumstances of these sorts of threats being made?
This is an issue I've expressed my position about, Mr. President, and I reiterate it and ask for your excuse if it borders on being unreasonable. But it remains my position, Mr. President and your honors, which is shared with my client, that the fact that there are efforts to unmask identity is not a reason to increase protective measures. Because, Mr. President, it is inherent in the request for protective measures that efforts will be made to unmask. So the mere fact that people are exercising that option that the prosecution anticipated in requesting for protected measures is not a reason. They shouldn't waive at any moment an effort saying, does this witness, is it a man or a woman or otherwise? The mere fact that somebody has tried to identify who this witness is not a reason for heightening protective measures.
Thank you very much. Mr. Khan.
I'm grateful, Mr. President, Your Honours. It's, of course, worrying news, and we are very much in the dark by the rather general comments made by the President. That said, we are grateful for the opportunity to address the bench. The first aspect, before I deal with the substance of the response, because we have some experience of the press in Kenya, and I'd ask the bench to make it crystal clear that there is no suggestion whatsoever that there's been any attempt by this defence team representing William Ruto to do anything other than comply to the maximum with all orders of the trial chamber and all the duties and responsibilities that flow from being officers of this court. Your Honour, in relation to the substance, it also repays, in my respectful submission, to recall that both in our opening and prior to the commencement of trial, in public press statements in Kenya, Mr. Ruto and myself on his behalf, on his instructions, have beseeched the people of Kenya, the press of Kenya, to act responsibly, to give, the exact words were, to give ICC space to do its work. And all witnesses, of course, should feel free to come here and speak the truth. Your Honour, so we would be vitriolic in our criticism of any attempts to suborn or go behind the orders and authority of the trial chamber. That said, Your Honour, we do have information, as I've said on a number of occasions, that certain witnesses have been promised that they can lie with impunity before this court in closed session. And there are intermediaries, and I can address you in ex parte session, that we have information about, that have been part of that conspiracy and that